Scheck versus United States was a Supreme Court case that explained some limits to the freedom of speech afforded by the First Amendment. During World War I, the U.S. instituted a military draft. Many people released anti-war and anti-government information due to their displeasure with the draft. Charles Scheck, an anti-war socialist, was arrested by the federal government for circulating a pamphlet encouraging men to resist the draft and violating the Espionage Act of 1917. The Supreme Court ruled that the wartime circumstances changed the rules related to free speech and resulted in the clear and present danger rule. The case of Neer v. Minnesota was heard in the United States on January 30th, 1930. J.M. Neer, the owner and operator of a newspaper, was arrested for spreading hateful speech. In response to his arrest, Neer appealed by claiming the state of Minnesota had violated his First and 14th Amendment rights. Neer also explained that his paper was expression and not illegal nor criminal in nature. The United States Supreme Court, in the case of Neer v. Minnesota, ruled in favor of J.M. Neer by stating that the Minnesota gag law was a direct violation of the First Amendment on the United States Constitution. The ruling of Neer v. Minnesota distinguished between hateful speech and hateful actions. It was found that the newspaper was not an immediate danger, nor did it present immediate harm to the population.
I'm going to talk about three cases today, the first one being Plessy v. Ferguson. Some background about it. In 1890, the state of Louisiana enacted a law that segregated certain accommodations between white citizens and African American citizens. Now, this case centralizes around Homer Plessy, 1/8 African American, and Judge John H. Ferguson. In Louisiana in 1892, Plessy boarded a white-only car and was asked to move to the African American car since he was 1/8 African American. He refused and was arrested. Now, his case reached the Supreme Court in 1896, and it was to answer the question of whether or not the laws enacted in 1890 were an unconstitutional infringement on privileges and immunities and on the Equal Protection Clause of the 14th Amendment. In its decision, the Supreme Court upheld the doctrine of separate but equal, meaning that as long as facilities provided to each race were equal, state and local government could require that services, facilities, public accommodations, housing, medical care, education, employment, and transportation be segregated by race. This is a review over the case we just went over. I encourage you to pause it and take a look at it. The second case we're going to be talking about today is Miranda v. Arizona. Some background about this case. In 1960, a movement which provided defendants with legal aid emerged from a collective efforts of various bar associations. This led to the creation of the Legal Service Corporation. Now, this case centralizes around Ernest Miranda and Chief Justice Earl Warren. On March 13, 1963, Ernest Miranda was arrested by the Phoenix Police Department based on circumstantial evidence linking him to a kidnapping and rape of an 18-year-old woman 10 days earlier. After 2 hours of interrogation by police officers, Miranda signed a confession to the rape and kidnapping charges. However, at no time was Miranda notified of his right to counsel. This case reached the Supreme Court in 1966, and it was to answer the question of whether or not police officers should notify an arrested individual of their rights, and should a confession be admissible without someone knowing their rights. The Supreme Court decision upheld the Fifth Amendment and the right against self-incrimination, and that they are valid in all cases. Police officers must explain the rights of the accused at the time of arrest, or statements confessed are not valid in court. This is a review over the case we just went over. I encourage you to pause it and look at it. The third case we will be talking about is Texas v. Johnson. This case centralizes around Gregory Lee Johnson and Chief Justice William Rehnquist. In 1984, Johnson, a member of the Revolutionary Communist Youth Brigade, participated in a political demonstration during the Republican National Convention in Dallas, Texas. The demonstrators were protesting the policies of the Reagan administration and certain companies based in Dallas. At one point during the demonstration, Johnson was handed a flag and set it on fire. Johnson was arrested and charged with vandalism. This case reached the Supreme Court in 1989. And it was to answer the question of whether or not that type of symbolism was protected by the First Amendment and whether or not it caused or threatened to cause a breach in peace. The Supreme Court held that the burning of American flag is a symbol of freedom of speech and therefore is protected by the First Amendment. This is a review of the case we just went over. I encourage you to pause it and take a look at it.
Okay, so the Lemon v. Kurtzman 1971 Supreme Court case between Alton Lemon versus David Kurtzman. And this was mainly a court case between Pennsylvania and Rhode Island, where they passed a couple statutes back in 1968 and 69, which allocated some money towards private schools. And the big main issue was pretty much teachers were getting money for their salaries, and pretty much a no-no because pretty much violated the Establishment Clause of the First Amendment, which the Supreme Court did end up ruling. And from this came the Lemon Test, which pretty much set up a way to figure out whether or not any statutes passed by a state are violating the Establishment Clause, which pretty much said that any statute must have a secular legislative purpose. Its primary effect cannot promote or inhibit religion, and it can't foster government entanglement with religion. All right, so Gitlow v. New York. Basically what happened, Benjamin Gitlow and the state of New York went to court, and he was pretty much arrested for criminal anarchy in New York City. Basically this happened between November 1919 to about June 8th, 1925, of when this occurred, between the state court's verdict and the Supreme Court's verdict. The first in which the Supreme Court upheld the 14th Amendment's due process clause that requires state and federal governments to hold the same standards of regulating speech. This is the first time they upheld the 14th Amendment's due process clause. And basically some context was that Benjamin Gitlow was a communist and was arrested on charges of criminal anarchy for publishing the Revolutionary Age, or the Left-Wing Manifesto, which was basically calling for the overthrow of the U.S. government. And he was given 5 to 10 years in prison, but from the state court. And then in 1923, the Supreme Court took it up and reaffirmed the verdict. And, basically, he still had to go to prison, but the 14th Amendment and the Due Process Clause was upheld.
Yo, we back at it. I'm Tommy Escobar, and I'm doing Marbury versus Madison. And it is arguably the most important court case in Supreme Court history. And the reason for that is that it applied a principle of judicial review, and that is the power of federal courts to avoid acts of Congress in conflict with the Constitution. It was written in 1803 by Chief Justice John Marshall, and his decision played a key role in making the Supreme Court a separate branch of government on par with Congress and the executive branch. Tommy Escobar, we're back at it. And you guys might want to hold on because this one's a doozy. This is a Supreme Court case, McCulloch versus Maryland. And in 1819, the Supreme Court ruled that Congress had implied powers under the necessary and proper cause of Article 1, Section 8 of the Constitution to create the second bank of the United States, and that the state of Maryland lacked the power to tax the bank. Arguably Chief Justice John Marshall's finest opinion, McCulloch not only gave Congress the broad discretionary power to implement the enumerated powers, but also repudiated in ringing language the radical states' rights, arguments presented by counsel for Maryland.
Supreme Court case Gibbons versus Odin, which was decided in March 2nd, 1824. Basically, the story goes, Thomas Gibbons had a permit to operate a steamboat between New York and New Jersey under a federal coastal license. And he challenged a monopoly license granted to Aaron Odin, who had the same license to operate between New York and New Jersey. It went to the Supreme Court, and it was a unanimous court decision against the New York licensing requirement of out-of-state operators, saying that it was inconsistent with the Congressional Act. Basically, Chief Justice John Marshall developed a clear definition of the word commerce, which included navigation on interstate waterways, and he said that under the Commerce Clause, that regulation of navigation by steamboat operators and others for purposes of conducting interstate commerce was a power reserved to and exercised by the Congress. The Supreme Court case Harvard Land and Motel versus the United States.
So in 1964, the Heart of Atlanta Motel was accused of refusing to accept African Americans into their hotel, which violated Title II of the Civil Rights Act of 1964, which clearly stated that any enterprises had no right to select guests as they saw fit, free from governmental regulation. Supreme Court case Buckley versus Voyo. Now, this court case brought up two important points. The first being that restrictions on individual contributions to political campaigns and candidates did not violate the First Amendment, since the limitations of the FECA are enhanced to protect the integrity of the system of representative democracy. And the second being that restriction of independent expenditures in campaigns, the limitation on expenditures by candidates from their own personal or family resources, and the limitation on total campaign expenditures did violate the First Amendment.
Terry v. Ohio was a Supreme Court case that came about after the actions on the night of Halloween in 1968 in Cleveland, Ohio. Two men, John W. Terry and Richard Chilton, were acting in a way that an off-duty cop found to be suspicious. He approached them and asked them for information, and they didn't cooperate, so he frisked them and removed weapons from two of them. They sued, saying that this was an unreasonable search and seizure, which violated one of their constitutional rights. And the importance of this case was that in the decision by the Supreme Court, they upheld that the Fourth Amendment that prevented against searches and unreasonable searches and seizures was not violated by a cop when they were searching due to a probable cause to arrest. Gregg v. Georgia was a Supreme Court case that came about in 1976 in Georgia when Troy Leon Gregg was found guilty of armed robbery and murder. He appealed the ruling of the capital punishment that he was sentenced to on the grounds that it violated the Constitution and that it was a cruel and unusual punishment. The importance of this case was that the Supreme Court upheld the use and importance of the death penalty in the United States. Santa Fe ISD versus Doe was a Supreme Court case that came about in Santa Fe, Texas in the year 2000 when the school district in Santa Fe was promoting the dominant Baptist religion of the area, even passing out Bibles in public schools. And eventually a Catholic and a Mormon family that were in the schools brought it to the court asking for an injunction to remove prayer from football games and from graduation. The importance of this was that the Supreme Court ruled that a policy permitting student-led, student-initiated prayer violated the Establishment Clause of the First Amendment.
Okay, the Supreme Court case of the United States versus New York Times is in 1971. The New York Times wanted to publish, along with the Washington Post, they wanted to publish a document called the Pentagon Papers, which is basically the defense history, the war strategy of the United States during the Vietnam War. And so this was in 1971. President Richard Nixon proclaimed this espionage because it had secret strategies that the U.S. didn't want to release. So he sent out an executive action to ban the New York Times from releasing the Pentagon Papers. So the New York Times took him to court, and it was a 6-3 ruling in favor of the New York Times so that they could release the Pentagon Papers and any other document they wanted to without being censored or punished by the U.S. government unless the publication would cause grave or irreparable damage. Okay, the court case of Miller versus California took place in 1973, in which Marvin Miller, the owner of a business that distributed pornographic material, sent out pamphlets advertising his business, and some people were offended. So California sued Mr. Miller on behalf of the people who received his material. This led to a disagreement regarding whether the First Amendment has protection of obscene materials. The Supreme Court ruled 5-4 in favor of California, so it was declared that obscene materials aren't protected by the First Amendment if explicitly prurient or have lack of artistic and political value.
So in U.S. versus Nixon, the Supreme Court ruled
that the president would have to hand over any presidential recordings or other materials that would ultimately be used against him, and it basically stated that no man is above the law, and the president couldn't use his executive powers to withhold any information. And in Bush versus Gore, the Supreme Court ruled that Gore's recount in the 2000 election was unconstitutional. In Florida, Gore basically just ordered a recount in 4 counties where they complained of problems with the voting machines. And then in Planned Parenthood versus Casey, the Supreme Court ruled that the state was prohibited from banning most abortions, and also it threw out a few regulations such as spousal approval, which is where the wife would have to get her husband to sign basically like a consent form saying that he knew the abortion would take place, so they didn't have to do that anymore.
Alright, the first case is Gideon v. Wainwright, 1963. Gideon was charged in Florida with a felony and he requested a lawyer. They did not appoint one, however, because it was not a capital case. He was found guilty and he appealed, asking whether the Sixth Amendment's right to counsel in criminal cases extends to felony defendants in state courts. The court decided unanimously 9-0 in favor of Gideon.
Action.
This is Engel v. Tal, 1962. Dealt with the religion in schools and whether or not it violates the Establishment of Religion Clause of the First Amendment. It was a 6-1 decision saying that it was unconstitutional for a religion to be inside the classroom, and it was the first in a series of cases to completely eliminate all religious activities from public ceremonies, including schools. This is Korematsu versus the United States, 1944. In 1942, President Roosevelt issued an executive order granting U.S. military to ban tens of thousands of U.S. citizens of Japanese ancestry. Fred Korematsu, who lived in California, refused to leave his home, and he appealed to the Supreme Court, and a 6-3 majority upheld his conviction, forcing him to be eradicated from his home.
This is Alan Bake versus the University of California. This case takes place in 1977, and it follows Alan Bake, who was rejected twice by University of California Medical School, which reserves 16 spots for minorities. He sued the court and University of California, saying that affirmative action was basically hurting his Fourth Amendment rights. So the question was, did the University of California violate the 14th Amendment Equal Protection Clause? And the courts ruled in a 5-3 ruling that it did not violate the 14th Amendment. This is New Jersey versus TLO, which took place in 1984. Now, TLO was a high school student whose purse was searched and they found cigarettes and marijuana. So TLO sued the court, saying that the school did not have the right to search her belongings. So the question is, does the exclusionary rule apply to searches conducted by school officials in public schools? And the court ruled in a 6-4 decision that it can allow, schools are allowed to search students. This is Hazelwood versus Kohlmeiser, which took place in 1988. So it followed a newspaper called Spectrum, which is school-sponsored, in the high school of Hazelwood East, which was written and edited by students. There's a certain article the principal did not approve of, but the students claimed that if the principal were to take it away, it would violate their First Amendment rights to free speech. So the court ruled that the newspaper does not violate the First Amendment rights, since the school has the publishing rights to it. So the First Amendment did not require the schools to take away the newspaper.
This is the Citizens United versus Federal Election Commission. The Supreme Court on January 10, 2010, ruled a 5-4 stated that prevention of any funds for independent election communications by unions and corporations was in violation of the First Amendment freedom of speech. This overturned 2 cases, Austin v. Michigan Chamber of Convenience in 1990 and McConnell versus FEC in 2003. This is a Dred Scott v. Sanford case. Dred Scott was an enslaved man who had been taken to a free state and attempted to sue Elizabeth Ernst Sanford in 1846 for his freedom. After Dred Scott and John Sanford, Elizabeth's husband, went to the Supreme Court in 1856, in a 7-2 decision in favor of Stanford, the court was denied Scott's request and argued that Scott was not a citizen. They viewed slaves as property, which was protected by the Fifth Amendment. This was a significant court case because it not only not identified blacks as citizens, it viewed them as property as well.
Supreme Court case Baker versus Carr, 1962. So the basis of this case is that there's an issue of state boundaries and state counties and the representation in the state legislature. So the main problem was that rural counties with less residents have the same voting representation as urban counties with more residents. So the Supreme Court ruled that the counties of the lower chamber of state legislators must be based on the number of residents, thereby establishing one person, one vote. Supreme Court case Mapp versus Ohio, 1961. So the basis is there's a Cleveland woman named Dolly Mapp who was under suspicion for gambling activities, and the police broke into her house searching for a fugitive and found obscene material, not related to her suspicion at all of gambling. She was convicted of having this obscene material, and she appealed to the Supreme Court stating that this violated the Fourth Amendment of unreasonable search and seizure, and wanted the exclusionary rule that it should be made a part of the Fourth Amendment. And the Supreme Court ruled in her favor, establishing that the exclusionary rule was thereby made a part of the Fourth Amendment, stating that anything obtained illegally could not be held up in the court of law. Supreme Court case Roth versus United States, 1957. So the basis is Samuel Roth he owned a bookstore in New York and owned a book selling business, and he was convicted of selling obscene material from his bookstore. He appealed to the Supreme Court saying that this violated his First Amendment of free speech. The Supreme Court ruled against him, not in his favor. He was convicted, and the Supreme Court made the ruling that all speech is protected by the First Amendment unless it is obscene or, quote, utterly without redeeming social importance.
Supreme Court case Mond v. Illinois, which was decided in 1877. The question was, did the state impose rates deny the warehouse and elevator owners equal protection and due process under the 14th Amendment? The court ruled no on both counts. Waite, for the court, took a broad view of the state's police power. He argued that the states may regulate the use of private property when such regulation becomes necessary for the public good. Waite resurrected an ancient legal doctrine that supported his view. When property is affected with the public interest, it ceases to be jury's private only. Supreme Court case Griswold v. Connecticut, which was decided in 1965. Griswold was the executive director of the Planned Parenthood League of Connecticut. Both she and the medical director for the league gave information, instruction, and other medical advice to married couples concerning birth control. Griswold and her colleague were convicted under Connecticut law, which criminalized the provision of counseling and other medical treatment to married persons for purposes of preventing conception. The question was, does the Constitution protect the right of material privacy against state restrictions on a couple's ability to be counseled and the use of contraceptives? The court ruled that although the Constitution does not explicitly protect the general right to privacy, under the Bill of Rights, together the First, Third, Fourth, and Ninth Amendment create a new constitutional right, the right to privacy in marital relations.